8 p.m. Elizabeth Mundy versus Justin Clore. The defendant is not here.
Okay. Good morning, Miss Monday.
Good morning. I apologize. I'm in drop-off lines for kids.
Okay. What we're going to need to do is, I don't know if obviously you're going to why don't we do this? Why don't we skip over you? We'll go to another case, and then when you can stop.
Oh, thank you. Thank you so much.
All right. Yes. Sorry about that.
I'll be back on. Thank you so much.
Yes. So stay in the waiting room. I didn't notice that. Sorry. Okay. Let's go to Ambler.
Good morning to both of you.
Good morning.
Good morning.
Mr. Ambler, I'll ask you in this case, have you had opportunity to see the judgment and the UCSO that's being presented this morning?
Yes.
Do you have any objection or dispute with anything in the orders?
No.
Okay. Ms. Ambler, we're going to take some testimony from you. So if you'd raise your right hand, we'll have you sworn in, then we'll proceed.
Do
Okay.
you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
And ma'am, do you have the script that we would have provided you?
Yes, I do.
You can go through that now, but you do not have to disclose your address.
Okay. My spouse and I were married on September 10th of 2019 in Battle Creek, Michigan by a person duly authorized to perform marriages. I was a resident of the state of Michigan for the last, or for at least 180 days, and of Calhoun County for at least 10 days prior to filing the complaint for divorce. Now before the court, the allegations in the complaint were true when filed and are still true to this day. My spouse and I ceased living together as husband and wife on January 1st of 2023. We have 3 minor children born of this marriage, and I, Catherine Ambler, am not pregnant. There has been a breakdown of the marriage relationship to the extent that the bonds of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved at this time. If the court were not to grant a judgment of divorce, I would not resume a marital relationship with my spouse. And the reason for breakdown of the marriage is due to irreconcilable differences.
Okay, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The file does appear to be in order. We have a front of the court approval. The time frame has run, and the defendant is present, stating he does not oppose or have any objection to the entry. So as a result, the court will enter the orders. In this matter, you are then divorced. Best of luck to both of you. I hope everything works out for you. You're free to go and have a wonderful day.
Thank you.
Good morning to both of
All right,
you.
thank you.
This is a scheduling conference whereby the court puts in place various time deadlines and processes so that the case will proceed in an orderly fashion. So I ask first you, Ms. Foster, what issues do you believe to be in dispute in the case?
Really, honestly, nothing. We're in agreement on everything other than that just the marriage is just irreparable.
Okay. Mr. Foster, is that your understanding? Is you don't have a dispute on anything?
Yes, Your Honor.
Okay. Well, what I'm going to do is I'm not going to put in place a scheduling order at this time. And the reason I'm doing that is when we set the scheduling order in place, that initiates the mediation process whereby you'd have to meet with an attorney mediator. There's a cost associated with that. And if there's not a dispute, you don't want to incur that cost. So what I'll do is I will reset this matter out for about 45 days for a status conference and see where you're at that point. Ms. Foster, you're going to have to prepare the judgment of divorce, the uniform child support order, and a judgment information form, those 3 documents. I don't know if you're using a service such as MichiganLegalHelp.org or anything like that, but those documents would all be on their site. And so you just need to get with them or get on the site and prepare those documents. And once you've prepared those, you can submit them to the front of the court for their approval. And
Okay.
once they've approved them, then have Mr. Foster sign them. And then we simply wait for the time frame to run, and then we'll be able to complete the case. So we'll set it out about 45 days. It'll be 45 to 60 days. That'll give you more than enough time to prepare the documents, get them to the front of the court, and then we'll check back with you at that point and see if we can proceed. Okay? Any questions?
Actually, yes, I have one quick question. So Eli and I have been dealing with everything financially for our daughter between he and I. Do we need to take it through the front of the court, or can we continue to go through he and I?
You always have to have them approved by the front of the court, because the front of the court will check to see if there's public assistance involved. If there's public assistance involved, then it has to go through the front of the court. So
Okay.
any kind of public assistance, if you're on Medicaid, you're getting any other sorts of public assistance, it'll have to go through the front of the court.
Okay.
So, but you have to submit it to them, and they'll do the review and all of that. And once they've approved it and the time is run, then we'll be able to conclude it. So, you have any questions, Mr. Foster?
No, Your Honor.
Okay. Well, we'll let you both go, and then see you back in about 45 to 60 days, and we'll see the progress that you're making. Okay?
Yes, sir.
Okay,
Yes,
thank
sir.
you. Have a good day.
You too.
The plaintiff
You
is
too.
here. Thank you. Let's
Okay.
move on to our next case.
Mr. Westworth Jones, you know why plaintiff isn't here?
I'm sorry, you said, do I know why what?
Do you know why your wife isn't here?
I do not. I was expecting she would be. This is the divorce case, right?
Yes.
Yeah, I do not know why she isn't here. I'm sorry. I was expecting her to be.
Okay, what I'm going to do, because we're still early on in the process, I'm going to reset this for about 30 days. And what happens if she does not appear in 30 days at that next hearing, the court will dismiss the case.
Okay, so then it'll have to be redone if she doesn't.
Yep, she'll have to refile, or you'll have to refile or something.
Okay. Yeah, like I said, I mean, I was expecting her to. I took off work to do this, so yeah, I don't know why she isn't.
Well, that's unfortunate, but we have no idea either. So we'll reset it and give her another opportunity, and if she fails to, then the case will get dismissed.
Okay, and so will I get like piece of mail saying that?
Yes, yeah, you'll get a new notice.
Okay. All right.
Okay.
Thank you so much
Okay,
for
thank
letting
you.
me know.
Have a good day, sir.
You too. Bye.
Thank you. Have a good day. 24 at 8:03 a.m. Move on here to.
Okay, this matter is before the court on a status conference. In this case, we are waiting and attempting to get the front of the court approval. Mr. Eddy, have you submitted the required documents to the front of the court to get their approval?
I have, yes, sir. The judgment of divorce, the uniform child support order, and the domestic relations.
Yeah, the judgment information form.
Yes, yep. I have submitted those to the front of the court.
Okay, so when did you get those submitted?
I submitted them yesterday.
Okay, well, we can obviously get approval because it takes about 2 weeks. So
Yeah.
what we'll do is we'll reset this about 30 days and check back at that time to see see if we've got approval in that particular time. Okay?
Sounds good.
Okay. We'll let you go. You're free to go, and we'll see you back in about 30 days.
Sounds good.
Thank you.
Thank you. All right, let's go on to the next one here.
Thank you. You too. Hi there.
Are you now available, Ms. Bundy?
Yes, I am.
Okay, let me call this here again. So this is case.
Ma'am, are you driving?
No, I'm not. I was waving my son to go into school. He was trying to talk to me, and I said, just go.
Okay.
Yeah.
I wasn't sure. I could see
No.
movement, and I wasn't sure if you're driving.
No.
This matter is before the court for entry of the judgment of divorce. In this matter, the defendant, Mr. Clore, has not appeared at this particular time. The case is rather old, and as a result, the court will note proofs were preserved back on June 5th of 2024. does appear that everything is in order. We do have front of the court approval, so the court is prepared to enter the final orders unless you have any reason why we shouldn't, Miss Monday.
No, I am. Thank you for being patient, and I'm ready to move forward with that.
Okay. Well, the court will enter the final orders in this matter. That will mean that you are divorced. Best of luck to you. I hope everything works out for you. You're free to go and have a wonderful day.
Thank you, you too. Thank you so much.
Yes.
All right, thank you. And we're,
Bye.
okay, I'll open the.
Jesus, Jesus,
Yes, Judge.
which, our hearing, is that the December 9th or the December 10th hearing?
December 9th is the PPO show causes, and December 10th is the hearing with Matt Hauser for this case number.
Okay.
Yes, so let me open the record here now. The 37th Circuit Court is back in session with the Honorable Brian K. Kirkin presiding, Summer McKediak versus Mark McKediak. The defendant is appearing from Calhoun County Jail by Zoom.
Okay. Good morning, Mr. McKediak. I see we finally meet, notwithstanding multiple notices of hearing for you to appear in person, but
And I apologize to you, sir.
yeah. Well, I would have rather had you appear than to apologize, but we have two hearings. You have a PPO hearing on December 9 before, I think it's Judge Yost Johnson, and then our hearing on December 10th. And based upon your history, what assurances do I have that you would be present if the court set a bond that you could possibly pay?
I'm going to be taken to Gaylord, Otsego County, and I have to do 5 months up there. So no matter what, I'm going to appear no matter what. So
Okay.
doesn't matter a bond or not.
Okay.
I'm just waiting for them to come pick me up, sir.
Okay. Well, and with that in mind, obviously you're not going to be released. What'll happen, the court is going to continue the bench warrant that was put in place here, and the going to continue the no bond provision in this particular case, so that we make sure that you are present, because I don't know what would happen up in Gaylord, or if you would have a chance to be released up there. I don't know. And I want to make sure that we do have you present for the two hearings that we have coming up. So the court is going to continue the zero bond provision. So you will remain in jail such that we are able to get a hold of you when those hearings appear. You have any questions?
Yes, Your Honor. I know, I don't know what happened or whatever, but I don't see how Summer McKediak was granted full custody of Mark and Aubrey after she was the abuser. I don't know how that happened or what, but they took him out of my custody and put him in her custody. And she was convicted of 3 counts of child abuse against both my children. And she's continuing right now as we speak to abuse my daughter.
Okay. Well, what happens, sir, when these things come up like this, and I can, I guess, sympathize in that regard, but you have to appear at hearings, and you haven't.
Yeah, I know.
And when you don't appear, the court can't consider the evidence, and the evidence may be in your favor, but there's no way for us to do that if you don't appear. So what's going to happen is, again, that would be unfortunate. And if that is the case, as you state, then the court should be able to hear that, but I can't hear it if you don't appear. So,
Yes, Your Honor.
so what you're going to have to do is file your motions. You're going to have to appear, and then the court will be able to, again, assess and determine what the evidence establishes. And again, you may be borne out, you may be correct, and you may then have a return of custody, but we don't know if you don't appear.
Yes, sir.
Okay. You're free to go, and we'll see you back in December then. Okay?
Yes, Your Honor. Now,
What?
I'm so sorry. I have all my evidence for my evidential hearing that's on the 10th, correct?
Yes,
All my evidence and
that's
stuff
the
is
hearing on the 10th, correct?
Yep. All that stuff's at home. I don't have an attorney. I don't know how I'd be able to get any of my evidence to bring into evidence. So I
Okay,
don't know
well,
how
what
that's
you're gonna have to do is you'll have to get someone that, a relative or somebody that
My
would have the
POA.
evidence. What?
my POA.
Yeah, they can bring it into court. It has to be filed at least 7 days prior to that hearing, so you'd have to have it filed in person by December 3rd, 2024. And then you'll be able to reference those exhibits and be able to present them at that time.
Okay. And I got one more thing. Gaylord, all they're waiting on is for me to get this stuff, like my warrants and stuff, my failure to appear is all taken care of. And then they were supposed to come down and pick me up and take me to Gaylord because I have to do 5 months there.
They probably aren't going to pick you up until we're done in December.
Okay.
Okay?
Do you think the sentence would run concurrent?
I have no idea. I have no idea I have no idea what the case is that you have there or what they're doing.
Yes, sir.
Okay,
Thank you, Brian.
free to
You have
go.
a blessed day, sir.
All right, thank you.
Okay,
Thank you, Brian.
free to
You have
go.
a blessed day, sir.
All right, thank you. And we are going to, where was that?
Okay. Mr. Burnett, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Somewhat.
Well, what it's saying is if the court finds that you are, again, responsible and that you have not paid in this matter, court could hold you in civil contempt and sentence you up to 45 days in jail or 90 days if you'd had a prior contempt finding. Do you understand that?
Yes.
Okay. Court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Court will find that Mr. Burnett does freely and voluntarily waive his right to an attorney. Mr. Burnett, I'm going to have you raise your right hand, and Ms. Platic will have you sworn in, then we'll proceed.
Okay. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Ms. Platic, you can proceed.
Thank you, Judge. We're here on docket 2000 S. Burton versus Burnett. In this matter, Mr. Burnett is here after failing to appear for a show cause hearing on October 11th, 2024 before referee Croteau. In this matter, it is the 6th bench warrant. He's had 6 show causes and 1 finding of contempt. We're presently working from an order that was signed May 24th of 2024. Indicates he should be paying $500.50 each month. Last payment was made through income withholding for $96.47. That was on May 15th of 2024. Compliance was measured over 5 months since the time that the new order entered. During that time, he's made no payments. Current arrearage is $2,756.24 through the end of October. There was a $200 bond that was posted that front of the court's requesting be forfeited and applied. He has never been sentenced to jail in this matter. He booked into Calhoun County Jail for this charge on November 4th and bonded out on the 6th.
Okay. Mr. Burnett, do you contest or dispute any of the statements made by Ms. Platic?
Yes. I had an ongoing support order from 2012. I believe that was ended. I can't recall 2017, 18, around that time, because my mother had custody and I was helping her so much without paying child support. I was helping her out of pocket. And Ms. Platek and my mom, they spoke several times and they came to an agreement to stop my support order when my mother had custody because I was helping her so much. And ever since I've bounced around jobs, I've always known that my arrearages was being taken out of my income withholding. I had no idea that another support order was started because we agreed to give my daughter's mother back custody of my daughter because she finally got it together somewhat. And so I had no idea that a custody order was put in place in May because I was stabbed in the neck at my employer April 8th. And I was on workers' comp. So I didn't know anything of a support order that was put into place. And I didn't even know that you guys were using the address that was on file to my grandmother's house in Battle Creek. Somehow, some way, it was some confusion, I was told, when I was booked into the Calhoun County Jail back 3 years ago. When I came into the FOC office, when I found out about the motion hearing, that was October 11th, I was told that the mail was sent to my grandmother's house in Battle Creek. I was told by the FOC office that was updated through DHS. Katie's telling me that it was when I was booked in there in 2021 on a different charge. So I was confused. I had no knowledge of there being that my daughter's mother filed for a support order. I was stabbed in the neck April 8th, and I was receiving workers' compensation. The same thing I was just going back and forth with Katie about is that, to my knowledge, I thought whether it's Social Security, employment, unemployment, workers' compensation, I figured if I did, my arrears was getting garnished from my workers' compensation. I didn't know anything about I had a support order or anything because I haven't talked to Katie since 2017, 2018, when my mother stopped my support order. So the only child support anything I know about would be my arrears, which get took out of my taxes when I file taxes, get took out of my checks when I'm working. So I didn't know anything about a support order. Last time I dealt with Calhoun County, it's been about 7 or 8 years. So I don't know how my grandmother's address got updated to my address because last when I was dealing with Katie, my grandmother's address in Portage, Michigan, where I get mail over there, that's where I always received my FOC paperwork. And so I had no knowledge of any support order or anything because I was stabbed April 8th. And it says my last payment, well, which was from my PTO for my job. I just heard you guys say it was May 15th, but the order was signed May 24th. So I'm trying to get back up to date on what's going on. I'm not running from it. I don't run from anything. When I was paying child support, when I had the order, I was working. I faithfully got took out of my garnishments for my income withholding. As far as I recollect, every bench warrant I had from you guys was scheduled for a meeting or a checkup that I had to appear to because I had to keep coming from Kalamazoo to Battle Creek. And I was just telling Katie, I want to switch my case to Kalamazoo because I just can't keep going through this. My daughter lives in Kalamazoo. Her mother lives in Kalamazoo. I live in Kalamazoo. I just really want to get if I have to file a motion, whatever I have to do to get my case to Kalamazoo, that's what I want to do because I don't want to go through these things time and time over again as I did in the past 12 years, which forces me to lose jobs, which forces me to have bench warrants and to go through these same things while I live in Kalamazoo. She lives in Kalamazoo. And I feel like it would be a lot more contributing and beneficial if I was going through Kalamazoo.
Okay, well, I'll tell you, you can file anything you'd like to transfer the case, but I'll let you know that the court rule and statute do not allow a transfer of a case from one county to an adjoining county. If you lived in a county that was not adjoining Calhoun County, then you'd be able to transfer it, but you can't transfer it to an adjoining county. So you can file what you want, but I'll just let you know that that would not be granted if you file that. Anything else, sir?
I didn't know that the support order was started back up. I didn't know anything about it.
In that regard, you said that you received your mail at your grandmother's, and that would be the address that's on file. If you are at a different address, you have an obligation, and each of the orders that you have says that if you change your address, you have to notify the front of the court of the change of address. Otherwise, they'll keep sending it to the address they have because they can't guess at what your address would be at any particular time. So if you don't notify them, they'll keep sending it to the last known address.
Well, I notified them when I found out about the court motion on, I believe that was October 24th, October 25th. So I just came up there, filed the paperwork. When they said that the bench warrant was in lien for about 2-3 weeks, I was calling them. I knew nothing of the motion.
Okay.
I came up.
But you said that the action occurred, the order started up in May, so you're notifying them of the new address in October wouldn't change what occurred in May.
I never knew that it occurred in May because I
Well,
guess that
you said that. You said you when you were stating this, you said that back in May is when your the mother was given custody back, and you said she started an
back in May.
action at that point.
Back in May. She's been given custody back for over 2 years now.
Okay,
You
well,
I'm repeating what you guys said. You said that
what you're going to have to do is you're going to have to look at the court file and figure it out, and then you can file a motion if, in fact, again, there's a basis to do so. But that's up to you to do, and you're going to have to review the court file to make sure that it's accurate. Anything else that you'd like to tell me?
No.
Okay. So you were off work from sometime, as you stated, in April 8th of 2024. Did you go back to work?
I'm in the process of trying to find work now because my workers' compensation stopped in September. And my doctors told me that I need to try to file disability, but that disability could take up to 6 months to a year. So I have to find a job. I'm in the process of finding a job now. I had a job that was on the table, but they ran my background check, graphic packaging. I was getting ready to start at graphic packaging. I don't know if this charge came up around the time they're running my background check. And so that voided me from that job. But I'm currently in the process of trying to find a job. I have been going through ups and downs, going through rigorous times trying to find a job since I've been stabbed in the neck and received workers' compensation. I'm actually still employed through 4840 Solutions, but our location is a third-party company that works at Target Distribution. But they can't place me back at Target Distribution because the nature of the offense that was committed. The person that was prosecuted, he's never allowed to be back on the premises, even though I wasn't in the wrong and I was granted workers' comp and he was prosecuted. They still won't let me be back on the premises. So, and the nearest location is in Livonia or close to Southfield, Michigan, which is towards the Detroit area. So they can't place me out there. But I still receive my health insurance benefits and things of that nature. But my workers' compensation has halted.
Okay. What have you done since September to acquire employment?
Everything possible.
Well, that doesn't tell me anything. I want to know what you've done specifically to acquire employment.
Applying everywhere, updating my resume, checking back in with old employers I've applied for, graphic packaging, Denso I've reapplied for, Express Employment, EG Workforce Solutions, Michigan Works. I've even enrolled in the CDL program that doesn't start until January 6th, but everything possible I can do to find a job. I'm applying everywhere, constantly Indeed, constantly factories up here.
Okay. Why do you think you haven't been able to acquire employment?
I believe it has a lot to do with my criminal history, or I believe it has a lot to do when employers see the incident that happened at Target. I believe that they're scared to, or they're reluctant to give me the chance, or I'm not sure. I believe it has a lot to do with my criminal history and the incident that occurred at my current employer that happened at Target Distribution.
Okay. What's your education background, sir?
College, 1 year of college.
Okay. I will inform you, just so you know, that again, you have support obligation of $500.50 per month. You have a right to have that reviewed and have that modified if there's a basis to do so. So you can file a motion to have that reviewed.
Is there any way we can modify today or lower it or the payment?
No, because what you have to do, you have to file paperwork to establish why you're entitled to the modification, and then we have to have a hearing on that. And there's just no notice in this matter because the notice would be sent to the mother as well, so that she has an opportunity to appear if she wants. And so we can't do that today.
Well, I just got off the phone with her not too long ago, and she's in the process, she said, of even taking me off. Of lowering it or taking me off. She said I just talked to her because we got to go up to my daughter's school. I just talked to her
Well,
5 minutes
okay.
before this time.
That's fine. If she wants to get a hold of Miss Platic, she can always forgive the arrears and again, cancel the support obligation, provided there's no public assistance involved. So she can do that. But at this particular point, she hasn't, and we can't do it today because there's no notice to her. We don't have an opportunity to provide notice to her in sufficient time as required by the court rules. Anything else you'd like to tell me, sir?
No.
Well, what I'm going to do, Mr. Burnett, is we do have, you've got a lot of things working here, and I want to give you at least the opportunity. I'm going to adjourn this matter for 60 days, approximately 60 days. That'll give you 60 more days to acquire employment, 60 days to work out the stuff you can with the mother of the child and get those matters resolved. And if they can be resolved, then matters would be much easier to take care of at the time of the next hearing. The court would forfeit the bond previously posted in this matter. And so I'm going to do that. So we'll be back and send you notice. You're going to have to take care of a lot of things. You got to get together with the mother, get her in touch with Miss Platic to try to forgive the arrears and cancel the support obligation. Otherwise, if you are entitled to that. Also, you can file your motion to modify support in this matter, but that'll give you an additional 60 days, and then we'll have you back and we'll be able to determine what's going to happen at that point.
Okay, thanks, Your Honor.
Okay, we'll see you back at that time.
All right, thank you. Have a good day.
Ms. Platic, anything else?
That is all I had for you tonight,
Diamond Raven
Judge.
versus
Okay, thank
Joshua
you.
Raven.
Thank you.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This is time and place set for the evidentiary hearing on the revocation of paternity action filed by the plaintiff in this case. Ms. Raven, are you ready to proceed?
Yes.
And Mr. Raven, are you as likewise?
Yes.
Okay. Ms. Raven, why don't we do this is we'll have you sworn in. So if you would raise your right hand. If you would get on video as well so we can see you.
Oh, she's joined by telephone, Judge.
Oh, okay. Okay. So we'll have you raise your right hand. We'll have you sworn in and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Mr. Magnuson, would you inquire of the plaintiff?
Yes, Your Honor. Ms. Raven, can you hear me okay?
Yes.
Now, you are the mother of Heavenly Grace.
Correct.
And Heavenly was born during your marriage to Joshua Raven. Is that correct?
Correct.
Okay. When were you and Mr. Raven married?
Geez, I don't even remember. August 18th of 2013.
Okay.
I think it was the 17th, but all right.
Oh, it was the 17th, yes. It's
So
been a
Heavenly,
long time.
regardless, right. Heavenly was born during your marriage to Mr. Raven. Is that correct?
Yes.
But you're indicating that he is not the biological father of that child. Is that correct?
Correct.
Who is the father of that child?
Bradley Hamilton.
Does Mr. Hamilton have contact with the child? Is he involved in the child's life?
Yeah. Yep.
Okay. And as far as you know, he would want to cooperate in establishing paternity for that child?
Absolutely.
And you are willing to do that as well?
Yes.
Okay. When
We're
did you
engaged, so,
when did you and Mr. Raven separate?
2015.
December
Okay.
2015.
Okay. And following that, you had no sexual relations with Mr. Raven?
Correct.
And Heavenly would have been conceived sometime roughly around March of 2021. Does that sound right?
Correct.
Okay. So with that, there's no possibility in your mind that he could be the father of that child?
Correct.
And you participated in genetic testing, you and Mr. Raven, is that correct?
Correct.
And those results dated October 18th of 2024 indicate a 0% probability of paternity for Mr. Raven. Thank you. I have nothing further.
Okay. Ma'am, I just have a question, as I did see some paperwork that relates to Blaze. Do you have a separate action involving that child as well?
This was supposed to be for both of them. You guys did the DNA test the same day and everything.
Well, we might have done that, but the paperwork, we only have on the one child. Do you have something else, Mr. Magnuson, on Heavenly?
Everything was submitted for both.
I did not see genetic test results for
Blazely?
I have them.
I suppose what we could do is take proofs regarding both children and then subject to the presentation of those results.
Yes, why don't we do that?
Ma'am, Blazely is not Mr. Raven's child at all, either?
Correct. Correct.
And
She is.
Who is the father of that child?
Bradley Hamilton.
Okay, and same question, he's willing to step forward and care for that child and be a parent to that child?
Yes, sir.
Okay. And you participated in genetic testing with that child?
Correct.
And the results regarding Joshua Raven were 0% probability of paternity, is that correct?
Correct.
What is Blazely's birthday? So again, based on your prior testimony, there's no physical possibility that Mr. Raven could be the father of that child, correct?
Correct.
Nothing further.
Okay, thank you. Ms. Raven, what's the date of birth for Heavenly? I don't have that. Okay.
12/3.
Okay, thank you. I have nothing further. Mr. Raven, we'll have you raise your right hand. We'll have you sworn in and take some brief testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Mr. Magnuson, if you want to question Mr. Raven.
Sir, you heard the testimony provided by Diamond Raven, is that correct?
Yes.
Was that testimony all accurate?
Yes.
And you've had a chance to review both the genetic test results for both children?
Yes.
Okay. In your mind, is there any possibility that you could be the father of either child?
No, I had a vasectomy in 2017, so there's no chance.
Okay. Nothing further, Your Honor.
Okay. Okay. I have nothing, no questions of Mr. Raven.
And Judge, I did find in the file, we do have the generic orders from Michigan Legal Help, and there's one for each child. There are the motions. I just missed one of them, but they're both in your queue now to sign.
Okay. Okay, well, it looks like that explains why we had different pleadings, and I had something different than Mr. Magnuson did.
Yes, my apologies.
Right. So I guess I'd move for admission of both of those test reports and ask that the court make a finding. I believe there's been clear and convincing evidence presented.
Okay. Mr. Raven, do you have any opposition to the court accepting the DNA test report for the two children?
No.
Okay. And Ms. Raven, are you agreeable to have those test results admitted as evidence?
Yes.
Okay, thank you. Anything else, Mr. Magnuson?
Nothing further, Your Honor.
Okay. Court will make the following finding in this case. We have the children, Heavenly in 2021 and then Blazely 2024. Both of the children are covered by DNA test results that do appear in the file, which have been admitted as exhibits in this particular case. The court accepted those. Those did show a probability of paternity for the defendant of 0%. As a result, he is ruled out as to the biological father. The mother has testified that the alleged father is Bradley Winston Hamilton, that she stated that he has carried on a relationship with the children as a parent-child relationship. And as well, the testimony has shown that she separated from the defendant in 2015 and has not engaged in any sexual relations with him. So it's impossible for him to have, in fact, be the biological father of the children. Notwithstanding that, he had also testified that in 2017 he had a vasectomy. And so the court's taking all that in consideration. The court will determine that both of the children are not issue of this marriage and are children born out of wedlock, and the court will so find. Anything else, Mr. Magnuson, that we have to do before concluding?
No, Your Honor. Thank you.
Okay. We will get those orders signed. Ms. Raven, you can get those probably sometime tomorrow on. It's going to take a little bit of time for them to process those once they get those back. But after that, you could have those if you need to have new birth certificates or anything else prepared, that you can get those documents. Okay.
Oh, she's
muted. So, well, hopefully she can hear us. And court will then end this proceeding. You're free to go.